Hi, this is attorney Anthony Parent,
And attorney Amy Holbrook.
and welcome to our webinar, Everything You Never Wanted to Know About FBAR Penalties.
But must.
And just to let you know that it looks like we do have a near capacity audience today. And we do have our chat box to answer questions. And the way this is going to work is that while I'm speaking, Attorney Holbrook will be answering questions, and it will be the opposite when she's speaking. I anticipate not being able to get to every question. So just keep in mind of our email addresses right here. You can ask us your questions directly. Mine's right there, aep@irsmedic.com, and Amy's is alh@irsmedic.com. And with that, let's get started. And so where everything starts is with this form, TDF 90-22.1.
Treasury Department form.
This is not an IRS form. This form is filed every June.
So this is not a tax form, like we said. It's a treasury form. It goes to a completely different place, completely different time. And it is a way to report your authority over financial accounts that are in foreign countries. And that includes branches of American banks that are in foreign countries. Foreign financial accounts means it's not in America, unless it's on an army base or something like that.
And you have to file an FBAR report, even if you are not the beneficiary owner of it. If you have a signatory authority, say if you are a stockbroker and you happen just to have authority to sign accounts on a client's behalf.
Or business bank accounts, or your parents' bank accounts.
The threshold is $10,000 across all accounts. So that means if you have 10,000 accounts that are all worth $1, you would have to file an FBAR for each of those 10,000 accounts.
You would have to file an FBAR form for that year.
Correct. We're going to quickly go into the penalties right now because I know that's what most people are pretty concerned with. And this is how it works. The IRS can assess 50% of highest account value if they believe that your failure to file is willful. And they can assess a penalty of $10,000 per year if they believe it's non-willful. That is, it was an innocent mistake. Here's the important thing is the IRS can assess these penalties for multiple years.
Or not. It's totally discretionary. This is a very powerful tool that they have.
And I think really the way to understand just how powerful this is we need to look at the history. So we're going to start in 1970 with the Bank Secrecy Act. Now, a lot of you are probably aware that if you go to a bank and you try to withdraw or send more than $10,000 or you do anything suspicious, you're probably aware the bank is going to file a suspicious activity report.
If you go to the bank and withdraw $1 million, they have to tell somebody just in case.
And where did that requirement on the banks happen? It was in this 1970 Bank Secrecy Act. Well, at the time, one of the lesser known provisions was the filing of that there was a requirement to file foreign bank accounts. And the idea was that this would give law enforcement leverage to prosecute people for money laundering or other financial crimes such as drug dealing, smuggling, because those crimes were typically very hard to prove. But an FBAR form, failure to file an FBAR form was something that was fairly easy. So
I think this is the classic Al Capone problem.
Right.
Get them where you can get them. This is easy to prove. If you didn't file an FBAR, you didn't file an FBAR penalty.
And the problem with Al Capone is it was actually a pretty tough case for the IRS to prove because they had to do a lifestyle audit. There wasn't a form there wasn't the FBAR form that Al Capone. Otherwise, it would have been a slam dunk.
That's true. It would have been really easy.
So the FBAR form is out there for years and years and years, and
I should point out that there's kind of the FBAR Supercenter in Detroit. I don't know what it looks like, but I know it's very hard to get information from them. It's not digitized in the same way as your tax returns are. It's totally separate from the IRS in a sense.
It's part of the Treasury, but not part of the Treasury.
It's part of the Treasury, but not part of the IRS,
There you go.
which the IRS is the lion's share of the Treasury.
So the FBAR form's out there for many years, and for the most part, everybody who's a law-abiding citizen ignores it because there's already an obligation to truthfully report your taxes. If you're going to cheat on your taxes, you're certainly not going to send in an FBAR form. And so it's just sitting there out in the background, and a lot of CPAs know about it or maybe not know about it, but it becomes a custom not to file one for most taxpayers. And because it isn't a separate form, that tax software forms, all the major tax software did not link the FBAR form to tax returns at the time. So
I would say that when we say that it was customary to not file, not that it was customary to say we're not doing this, but customary to not even think of it.
That's right.
This was not even on the radar.
It's just think of it like, why, most people will drive 75 miles an hour on the highway, not even think about that they're breaking the law.
Everyone else is driving 75 miles an hour.
But things start to change. Things do start to change. In 1992, the Secretary of Treasury allows the IRS to start investigating FBAR matters. And because they just have a bigger, they're looking for more tax. The IRS is looking for tax evasion, where the Bank Secrecy Act is looking for crimes. And so if you could kind of see the difference between the two.
FinCEN is the Financial Crimes Enforcement Network. And with the Bank Secrecy Act, we talked about money laundering, financial crimes. In the 70s and 80s, we're talking about a lot of drugs crossing borders. They're looking for some real, I would say, sexy crime.
Right.
High-profile busts.
Right. Not mere tax evasion.
Not somebody who didn't file a form for $10,000 they had in the UK.
And so now the IRS is in charge of this. And then in 2001, we have a terrorist attack, and then the Patriot Act is used to help detect terrorist activity, something that the Bank Secrecy Act really wasn't trying to focus on.
The 70s was a different climate in terms of what we thought foreign accounts would be used for, laundering. Now we're concerned about foreign accounts being used for attacks on the United States.
And so attention starts to come to the FBAR form, and in 2002, the Secretary investigates to see what the FBAR compliance rate is, and it's found that it could be as low as 20%. We think it might even be a little bit lower than that. And they said that they needed to find a high-profile criminal to raise the cost of being an FBAR scofflaw.
This is basically, we're actually in the midst of this right now. What is essentially a huge PR campaign for the IRS to terrify people about not filing FBARs.
And it's working.
It's working. Yeah,
it is working because you should be terrified.
Well,
what happens in 2003 is now the Secretary of Treasury delegates just not investigation but enforcement authority to the IRS.
So previously, the IRS was able to say if they were in the midst of some kind of audit or other investigation, hey, FinCEN, we found there might be some FBAR problems with this person. In 2003, FinCEN's like, we have bigger problems. IRS, you have an entire collection enforcement division. Deal with this. We're not interested in dealing with this.
And so the IRS takes those reins and starts looking for cases to prosecute. And we'll be talking about some of those in a little bit. But the next really big development is in 2004 in the Jobs Act. Of course, this had nothing to do with jobs.
The Patriot Act was also voluminous with many, many provisions about many different things, as we all know.
So somewhere tacked on to the back of the Jobs Act, there was a nice little trick. A gift the IRS was granted. Previously, the IRS had the burden of proof to prove willful violations. And then in 2004, with a stroke of a pen, it changes. Now the IRS can assert a penalty to make it the taxpayer.
The taxpayer has to show reasonable cause for not filing rather than the IRS having to show willfulness.
And that's what most of our cases come down to, is showing a reasonable cause to lower the penalty.
I should point out that reasonable cause is not difficult to prove in terms of FBAR cases. Normally it has been enough that you didn't know about it and didn't file because you didn't know about it. That means you were non-willful. There are still non-willful penalties that are possible, is the thing.
And the way to limit, and the whole point about, to get to the point, and I think, what Amy said, it's not hard once you're following the right procedure to do it. If you are audited, the IRS finds it, and now you're trying to raise reasonable cause, you're going to have a hard time. However, if you come clean with the IRS and then explain the reasonable cause to them, that we have been finding that the IRS is doing what they said they were going to do.
And what I should say, we've talked a lot about tax evasion. Many of our clients and the people who call us have not filed FBARs but have not engaged in tax evasion. And the IRS has been perfectly willing to accept late filed FBARs with reasonable cause statements and say, just don't do it again.
Our first, in 2009, we had our first offshore voluntary disclosure initiative. And there was a one-time cap on an FBAR penalty of 20%, one time only.
This is for cases where there are offshore accounts that were associated with tax evasion, meaning that taxes were due that was not paid.
Right. So it was a great deal for people
Not that tax evasion was proven as a crime, which is a completely different situation.
The 2009 OVDI was a great deal for people engaging in intentional tax evasion over a series of years. However, it treated everybody the same, whether or not you made an innocent mistake, you didn't know it, whether or not you had $1,000 of income, or much, much more. It treated everyone the same. So in 2011, the IRS comes out with a new offshore program that increases the penalty slightly for those engaging in intentional tax evasion, but then lowers them substantially for those who made innocent mistakes.
Also, for lower account values, there's a gradation of penalties.
Right. Then in 2012, we see the same thing: slight increase for those engaging in intentional. The same thing if you did something negligent, the IRS gave you a lower penalty. And the IRS also came up with a streamlined program for those who are expats and have not filed tax returns. And if you just mind, I just want to catch up on some questions here. Now, what we want to talk about now is that there are some other FBARs. Now, we mentioned this Treasury form. The IRS has other informational returns, and these are actual IRS forms, not Treasury forms.
At this point, the FBAR itself has essentially become an IRS form where they haven't really changed it over yet. And we'll talk in a few minutes about how they also duplicated it with an IRS form. But these so-called information returns state to the IRS your interest in a foreign entity or other types of transactions, trusts, transfers that they might want to know about. It's not imposing or paying any tax, just showing that you own a foreign trust, that you're a shareholder in a foreign corporation. They want to know because
otherwise it'd be incredibly easy to circumvent the FBAR requirement by opening up a shell company and having that company own the bank accounts. And so the IRS has thought of that. And has these requirements, and with the failing to file these forms, you will see similar penalties to the FBAR. And so if you have unfiled forms like these, you also would qualify to get into the offshore voluntary disclosure program.
However, it is also true that if you have not filed these forms, but there is no non-payment of tax, for instance, there is a form to report yourself as a beneficiary of a foreign trust. That's not taxable. You didn't fail to pay tax. It is possible to file those forms and just say, my bad, move on. So not every
case requires an offshore disclosure for failing to file. And we'll show you our little chart we made to explain the process a little better for you. But right now, we want to talk about the cases that are pending out right now. And as we said in the history that the IRS wanted to raise the cost of being an FBAR scofflaw and needed a high-profile criminal case to prosecute. Well, that would be the Williams case. And the Williams case is somewhat interesting in that in 2001, Mr. Williams pled guilty to tax evasion. During the plea, he agreed that he had these accounts offshore and evaded the taxes. Well, the IRS realized that at no time did Williams file an FBAR. And so they brought an FBAR penalties against him when he got out of prison.
This is a great example of kind of what the form has become in terms of an enforcement tool. This is someone they already had on the hook for evasion.
Who paid his crime.
He did his time.
He did his time. He absolutely did.
And they tacked on these additional...
And this is after, he is probably, likely at this point, he probably has very little money left. I haven't talked to him, but...
well, the fact remains that I can't really speak for Williams and his state of mind, but he did do the crime, and I think pay for it, and was not prepared for the fact they would come back after he did this and hit him with new penalties.
Right. Yeah, in his defense, the reason why he didn't file an FBAR was he said, well, what possible purpose did I have to file one? I told you guys all about my accounts that I was evading taxes when I pled guilty. So what purpose? I would have no purpose not to file an FBAR unless it was something I simply could not have known about. If I known I needed to do it, of course I would have done it because there was no continued tax evasion. I pled guilty to that. And so Williams did win at the trial level, but then the IRS appealed it, and that was in the Fourth Circuit, and the IRS won. And it's just one of the most unprincipled decisions you'll ever see, and it's really that how much pressure that certainly the tax court or the I don't know if the FBAR law was quite known to the circuit court, but just something so unprincipled. Perhaps it's something that gets... I
would say that based on Williams and McBride, many district and other higher courts are not really familiar with tax law.
And they don't like it.
The Supreme Court does not want to take a tax case.
Right, and that's the thing.
But they're willing to take they're willing to take the lead of the lower courts, and in this case, the IRS's position has been that non-filing of FBARs is part of a tax evasion scheme. The same thing happened to McBride.
Right, and in McBride, the situation is kind of similar. That McBride had these accounts that actually he had these foreign accounts that he bought into a international tax deferment scheme. It
was a supposed investment opportunity by a company that was sort of helping people to avoid taxes.
But and we did have the opportunity to speak to Mr. McBride and do some research, and we looked at the program that he was getting into, and it was not something that was very, I think, did not appear that scammy to me. It took arguably it was taking advantage of something known as deferral, which is the backbone of all international tax planning.
Well, Anthony, I think that the most relevant point here is that to us, tax attorneys, it was not especially clear that there were bank accounts involved.
That's the other thing, too, that there really weren't bank accounts because the accounts were held by this company in which he may have had shares, but the company would never give him an accounting of what he exactly had control over. So that when we look at the FBAR, when we look at the simple rule of do you have signatory authority, we looked at it and says no. And is it a financial account? It's sure, but it's owned by somebody else who you may have an attenuated claim against, and so that it looked like he didn't even have an FBAR requirement. And then he even goes later to get an opinion from a tax law firm in New Jersey, and he submits it to court to say, he asked for a professional opinion to say, do I have an FBAR requirement? And this is years after, while an audit is going on. And the attorney says, no, there's no FBAR requirement. And that wasn't enough to protect him. Because in this case, and this is something that you do need to know about McBride, is that his financial condition is he doesn't have any resources left. That the audit the IRS had against him and this criminal charges, plus the money that this offshore scheme stole from him, and it's something that he tried to assist the U.S. Treasury in prosecuting the people who scammed him in what he describes a Ponzi scheme, he left him totally bankrupt. And yet, and this is the thing you need to know, is that the IRS wanted to get somebody. and it didn't matter who it was. It didn't matter the price. McBride, he did some strategic things. He represented himself during early stages of this, and that didn't help out. His attitude wasn't cooperative, and so the IRS takes a look at him to say, we can get this guy, let's go for him. And then the district court in Utah ruled against him. I talked to Mr. McBride about if he was going to appeal this. He said that he really didn't have the resources to do so, and he would probably just try to settle an amount with the IRS, and it might be something where the IRS is just going to, where he will file bankruptcy.
I think that, to bring it back, the moral of Williams, the moral of McBride, the moral of plea bargains, which are not publicized, because
not all of them are. But if you do look on the IRS, the website, that you'll see that a lot of the plea bargains that are happening is that the IRS has this tool. And again, remember how
the moral being that if you wait for them to get you, there's no getting out. Proactive steps are the only way out.
That's really it. That's what they're showing, that they will take somewhat unprincipled stances. Do not expect justice. That's really the thing. They are not interested in justice. They are interested in prosecuting these cases very seriously to scare you, to make sure you do the right thing when dealing with unfiled FBARs. Now here, as we said, we wanted to have our chart. And when we're saying unfiled FBARs, by FBARs, we're also talking about those other informational returns.
For most people, FBARs are the relevant form.
So this is the key distinction. If you have no income from the accounts,
no unreported income where tax was not paid. If you have income and you reported it and paid it, it's fine.
Then this is what you need to do. You need to file FBARs for 6 years, then send them to Detroit with an explanation why the forms are late. And this is something that we do for many taxpayers around the world. And then no penalties should be assessed. And as we have been doing this for a few years now, that's been the case. We haven't
totally lived up to that. If you've done this correctly when you should have, they aren't interested in pursuing most of these if you step forward and brought it to their attention.
Now, if you have income from the accounts that you did not report,
tax was not paid when it should have been paid,
then it's going to be one of the offshore voluntary disclosure programs. That would be the appropriate next step. That is the appropriate next step. And we are going to, we don't have time today to talk about all the OVDP programs. We will be doing a webinar with that coming up shortly, but just to give you an overview, what we typically look for is, what we typically have to do is file all missing FBARs, and amend all returns. And it's just
back 8 years, not 6 or 3.
And submit ourselves to the scrutiny of the IRS. And basically what's going to happen is we submit the returns and supporting documentations, and an IRS examiner will audit those to make sure the numbers add up. Once there's a figure about how much is unpaid, that bill is paid, and then it comes down to whether or not what the penalty amount should be. And if it's an issue where our client was engaging in intentional evasion, we just go with the standard penalty. And if it's something where our client has reasonable cause, we present that to them to lower their penalty amount.
Maybe. This is a very complex topic. We'll really have to get into it in more depth in our next webinar. But the Offshore Voluntary Disclosure Program, we just spoke about it a little bit, so I want to keep it to a minimum. It's just a special unit the IRS has invested a lot of money and resources in to deal with offshore issues, to deal with people coming forward and disclosing these issues so that their FBARs and amended returns are submitted to examiners who understand what they're looking at. After application to the program, you are submitting all of these. The penalties are locked in at 27.5, 12.5, and possible 5, or potential penalty negotiations based on reasonable cause. As we discussed, that is an entire webinar in and of itself.
Amy, I have a question for you.
Ask me.
What is soft disclosure?
Soft disclosure is not anything.
Well, what is quiet disclosure then?
So there are practitioners on the internet or presumably out in practice, who had this idea. And I have to tell you, I had the same idea.
I had the same idea.
I did too, because it seems good. It seems like, wow, this is a nightmare. There's so many penalties. But if you file your back FBARs, you're not going to get a penalty, right?
And if
then you just amend your returns.
And if you amend your returns, pay the taxes you owe, how can the IRS possibly get you for tax evasion? You pay the taxes you owed. So why would anyone enter into this program where you're subjecting yourself to the scrutiny of the IRS? Why wouldn't you just do it on the sly, Amy?
So in opposition to the voluntary disclosure program, which people are really afraid of, they say it's really unfair. It is really unfair. But they've come up with this idea of quiet disclosure, where you're disclosing, but you're not making a big deal of it. You're just kind of getting them in there and hopefully not getting any penalties.
And so we want to talk about why you shouldn't do it. So our number one reason why is
the IRS told us not to.
The IRS told us not to do it.
They say it explicitly in the OVDP FAQ. They have also said it explicitly to us as practitioners.
That's right.
The Commissioner of Revenue is really interested in going after taxpayers and practitioners who are engaging in or advising quiet disclosures.
And I think if there's anything that McBride and Williams have told us is that the IRS isn't necessarily isn't really out for justice. They're out for compliance. And I think those are two different things.
I think it's possible to argue. And
sometimes they overlap.
I think it's possible to argue, and you and I might argue between ourselves, whether or not they have some convoluted good intention in all this that is being completely miscarried.
But if you see how they in both Williams and McBride, that they really didn't do anything, that in either case the FBAR penalties are just not appropriate for their behavior. One, simply because one didn't have a requirement to file an FBAR, the IRS felt different. And the other, there was no practical reason for the taxpayer not to file an FBAR.
And they already got them on tax evasion and got the revenue.
And they got them anyway. And so that's really the thing. They say not to do it. They have the power.
And the other lesson of McBride and Williams, especially McBride, Anthony talked about this earlier, play ball with the IRS. If they think you're being uncooperative, then it's not going to go well for you.
That's right. I mean, when we raise the reasonable cause arguments through the proper channels, we get a receptive audience. When you do it outside, you have an uphill battle.
It's done properly in a maybe non-aggressive way, maybe more of a collaborative approach of we're all looking for a fair solution for taxpayers. No one, well, I don't want to say no one, but most people that work at the IRS are trying to feel good about what they do. And
that's right. And they do. And if you come clean and do it their way.
And if you act like you are an angry tax evader, then they do not want to see a good result for you.
And that's what McBride admitted. And he said that he didn't handle it correctly and that he should have. He gave the auditor a hard time. And that's one of the things that really he claims was the reason why he was treated this way. And then the thing we want to bring up here is if anyone's telling you now, to do a soft disclosure, quiet disclosure, if you hire anyone to do it, I want to tell you right now, run away from them. And if you have done one, if you have done a so-called soft disclosure or quiet disclosure, do the real thing now. And this is the reason why. As Amy said, the IRS has told us that they are going to prosecute practitioners who advise soft disclosure. So this is how things are going to work in the real world. The IRS is going to catch someone, and I'll explain to you how easy it is for them to catch it. They're going to catch a taxpayer, and the taxpayers they're going to catch a taxpayer who did a soft disclosure. The taxpayer is going to turn. Taxpayers,
they're going to make a plea bargain.
They're going to make a turn, or hopefully even avoid criminal charges by ratting out the advisor who told them to do that. Now, this is what's going to happen. Once the IRS knows the advisor, they say, oh, great. Now we're going to go to the advisor. We're going to shut down their office. We're going to subpoena we're just going to take all their records. We're going to padlock the place. We're going to go through there and to see everybody, every other client that this practitioner had. The IRS is going to be in everybody's business. So it's really a situation where whenever you're dealing with anyone who's advising you, you are exponentially increasing your risk, because the IRS, your risk is that anyone who else is their client gets caught. That means you'll get caught. And now, where is your leverage to, when the IRS gets you, where's your leverage to rat out your practitioner? You don't have that. And so the IRS could really, really, put the screws onto you. And where I said that it's so easy for the IRS to detect these soft disclosures is that there's a new Form 8938. And so the new Form 8938 actually goes on your tax return. And in order to file it correctly, you have to be honest about where this account came from, how big it is. And so even if you don't file FBARs correctly, the IRS can immediately see that we have an offshore issue here. Now your choice, is if you don't want to file a Form 8938, you could just lie on your taxes and then be guilty for a crime of tax evasion. So it's really or tax fraud. So it's really easy for the IRS to find that.
I think that maybe what we've said in the last couple of slides sounds like we are really demonizing practitioners who advise this. I think that they're coming from a good place where they're trying to make sense of something nonsensical.
Yeah, and that's absolutely right, because Amy and I see cases where we just shake our head. It's just that we see cases where the amount is just not that big to justify. It doesn't seem fair that a client has to go through
$500 in taxes,
and now you have to go through this
but the
big
penalty will be $12,000.
Right. And our instinct as a practitioner looking out for clients is to say that just can't be right. That can't be right. It can't be fair.
And the practitioners who've come to that conclusion are thinking, well, that can't be right. It can't be fair. The IRS made this program for your Swiss bank businessman, big whale. A big whale who has tax evasion problems and huge accounts. And my client has a small account in India, and it's totally different, and it must not be what they're looking for. This is the whales and minnows discussion you will see on certain parts of the internet.
My friends on the internet, this is what they say, that they'll tell me that the IRS is only interested in whales and not minnows. And I would get into disagreements with them. And then, you know what? I finally said, you know what? You guys are right. You guys are absolutely right. The IRS is only interested in whales. But then it's like, what is a whale? And a whale necessarily isn't a big fish. A whale is something that the IRS is looking for a slam dunk case. Okay, that makes a whale. A case easy for the IRS to get in and out, get a plea deal, get a lot of money. Well, the FBAR penalties allow for that. The penalties are so huge that they have this leverage and a really low burden of proof to show, okay, we get it. So that's satisfied.
Anthony, I disagree with you on one thing, and I'll tell you what. You're talking about easy to get paid. I don't think they care about the money at all.
Yeah.
We see
easy to get a press release showing what it is.
In our resolution practice, we also see the case. The IRS is not letting go of you because you only owe $1,000. IRS agents, like in many other industries, work on metrics. How many cases do you close? Were you successful? They want a case that they can close, not that is a huge amount of money. It's something that they can say, I closed cases this year. That's how you get.
So maybe we should change the easy to get paid part to something easy to make it look like you're getting paid. Yeah, I agree with you there.
The IRS is not as interested in collecting revenue as in preventing the loss of revenue?
Right. Well, creating an identifiable goal and then saying we've closed out this identifiable goal. And so that is really true, that they're really not interested, that the IRS, and right, we see this in McBride and probably Williams too. But we know from McBride, they're not going to see that money. That money that they got, they are not going to see that.
This is just a little afield, but I think it is interesting, is that there was an internal IRS report years ago about how penalties work. And what the report ended up saying, all penalties, the IRS. And the end result of the report was that, in the opinion of, the council that wrote it, the point was not to receive revenue. It wasn't to make up for lost revenue. It was advertising the high cost of noncompliance. And that's what you see here.
That's right. So we'll make a change to that. You're absolutely right. Now the other thing too is when I say easy to get a plea, this is what the IRS will do. When I say IRS, I usually mean Department of Justice as well. That what they'll do is they'll charge both spouses if there's a joint return, even though one spouse might not have known anything about it, and that really puts an incredible strain on a marriage. And so typically, a husband will take a really unfavorable plea just to get a wife not charged. And so some of these unfavorable pleas that we see and that we mentioned before, some of these huge penalties, you're talking about somebody paying $23 million for maybe $900,000 in taxes evaded, $23 million. So the amount of the penalty, and still subject to more jail time too.
It is not uncommon at all to see, even in the cases of offshore voluntary disclosures with capped penalties that are 25, 100 times the tax owed. And so hopefully you understand that the whales versus the minnows, and that I have that our firm has been we've been accused of a lot of things, being fear mongers, but we really deal with the IRS every day. We are paranoid because
we pay attention. Yeah.
That's what we've seen happen.
Yeah, and you should be paranoid, especially here. This is, really, unfiled FBARs. I would just say that, it's like a third rail. It's really something dangerous here that needs to be handled correctly. Well, we're just about done with our webinar, and I'll just give a few minutes here or a few seconds to catch up on some questions that are outstanding.
I think we better wrap up, or else we will talk about FBARs forever.
This is what we know. And so that, we want to know, we're on the same page as you. We don't think FBAR penalties, we don't think they're fair. We don't think any of this is fair. We think that, so one of our clients, you had a great quote by one of our clients the other day, who said, the IRS always comes first. Can you explain what did she mean with that?
I had a client who was a citizen of 3 countries. I'm not sure which she was born in. It wasn't the U.S., but she had lived in the U.S. for 30 years or so. And she was very frustrated. She said, "Why does the United States always have to come first on money that I made overseas that I never thought I had to do anything with?"
And that's one of the things, is that the IRS has universal tax jurisdiction. It taxes you anywhere from income you make just because of your citizenship, not where it's made. And the only other country to share this taxing regime is North Korea. And so many people expecting a civilized tax system who come to this country find that that's not what exists, because the IRS has the power. And that's what you have to understand, that everybody, I don't care how big you are, you are a minnow compared to the IRS.
I think
even though the IRS may think you're a whale. How's that?
Jump back for 1 second when we talked about the IRS taking over enforcement authority of the FBAR. It's because the IRS is the most efficient loan collector, or debt collector rather, that there is. They can grab everything
without court orders. They don't need court orders to grab stuff, and no one has that power.
IRS comes first on every.
And that's just the way it is. And you have very limited choices. Even if you want to leave the country, you still have to file an exit tax with the IRS, and that
anyone talking about giving up their citizenship to not pay taxes,
you still have to comply with the IRS, or they will say you never left the country properly. Therefore, we get to still tax you even though you left and gave up your citizenship.
It's fun.
It's something else. And one of the things you need to know right now, what's going on. The IRS, as Amy was alluding to earlier, that the IRS is investing a ton of money into this offshore, all this offshore stuff. That, New York, we're in Connecticut, and New York is a huge, huge center of unreported accounts.
Well, they also have Texas. They have Florida. I think they have Missouri. There's several of these centers.
These centers are forming around the country, and their whole idea is to catch people with these offshore
I have to say, I don't know if any of you out there are listening, but they're sending their best and brightest.
And that's right. We talked to IRS auditors, because we do have a regular tax resolution practice here. We talked to the auditors, and they're all saying that they sort of quieted down. Our regular audits have quieted down, and we're wondering what's going on. So we asked, well, where did so and so go? And we're informed. They went to the offshore center in New York.
I got the impression that the offshore auditors are the real sharp ones.
They are. There's intense competition to be an auditor there, because again, you have the metrics that we're talking about, huge assessments, and the ability to really and really the intense threat of criminal prosecution that will get these cases moving. Something that, if you're auditing, I guess, your typical plumber who hasn't paid, who has some owes money, that plumber's really not going to be all that scared about going to jail. And it's sort of, people know that. But, this is totally different for somebody with unreported offshore accounts, because that fear is real, because that is the focus of what is going on. The other thing, too, and I guess this is where I would just sort of, what I said earlier about the IRS wants to get the money. There is a recent report out that the IRS, the Government Accounting Office, and Congress took a look at the IRS collection metrics. And their point was, why are we bothering auditing people and giving them big bills when they necessarily can't pay it? What we really want to do is go after people who actually still have money. In this tough economy, we are settling taxes, every day for fractions all the time. I was going to say pennies on a dollar, but I don't think I'm allowed. But it is pennies on a dollar. Sorry, that is actually how it works.
But many of our clients with offshore accounts are, if not wealthy, they are comfortable.
Right. Well,
they have a comfortable life.
Well, they're comparatively wealthy to somebody who has nothing. So even if you don't identify as somebody who's wealthy, the IRS does, because you have something that a lot of people don't have, actual assets. So that's really the thing, is that's sort of the focus on this. And if the thing you need to know is if you have unreported income, okay, the only solution, regardless of how unfair you think it is or how unfair we think it is, the only way to put this behind you permanently
right now, based on what the IRS has told us,
is by entering into the Offshore Disclosure Program, in which we will be doing that webinar, as we said, shortly. If you're on this list, you will get notification of when that webinar is up. If you do, and here comes, I think, our sales pitch, is that if you do want to schedule a teleconference, you can do so. Just email us at info@irsmedic.com. We'll set that up with you. Anything you tell us is 100% confidential.
It's true, we're attorneys.
That's true, unless you do what? If we advise you to break the law.
Well, yeah, then.
Which we won't do. And if you tell us you're going to break the law,
we'll tell you not to do it.
We'll tell you not to do it. And the other thing, we might be a little bit different, that we do charge flat fees, and we'll give you our fee for our services up front before you're on the hook for anything. So with that, I think we will conclude our...
I'm real pleased with everyone turning out today. I hope you learned a lot. I hope we could get to some of your questions. And
we'll try to get to... So please, and I know there's some more questions, so again, please feel free to email. And if you want to if you have any other questions, you can email also info@irsmedic.com with other questions that you might have.